share my thoughts on this contract of employment. As a matter of fact, it's very difficult to speak after Dr. Krishnamurthy speaks, because he covers almost the entire topic. There is one small secret I want to share with you. This morning when we were coming together from his house, he read all my notes and he has told you what I have written. Be that as it may, contracts are supposed to be made by the free will of parties. The agreement or the terms of agreement in the contract are supposed to be both precisely expressed or it could be implied as well. The terms normally are very clear as to what the parties should do, and it creates legal relations between the parties, and it is for a consideration. This generally sums up what a contract is. I spoke about the implied terms. In one of the decisions, in the Hindustan Univer's case, the employer had written 3 letters to the union saying that the sales force or the field force in the sales department, the company will not contest any dispute by saying that they are not working. Now, these were mere letters, but then the Supreme Court said that you cannot now go back because both of you have acted on the basis of those letters, and therefore they will be treated as workmen as far as the company is concerned and as far as the dispute is concerned. So therefore the implied terms are also very important as far as the employment contract is concerned. I also spoke about the free will of the parties. There is an exception. Section 25FF speaks about transfers of undertakings. And when one company is merged to the other, the merging company's employees have no voice or no right to say that those contracts or those terms of employment are not applicable to me. So this is the exception. Many of the employers today are finding a short route, and they are not closing down firms because you need to obtain permission from the government. Instead, transfer the undertakings and get away from the employees. In Standard Chartered Bank, I think during Sharad Patil's time, we used to say, if any company takes one employee from Standard Chartered Bank, 2 employees will be given free. Most bankers refuse to follow it, refuse to take that bite. So this is the thing as far as 25FF is concerned. The employees of the merged company, they have either the right to compensation or their services can be safeguarded by continuity of service, but they cannot get both. In other words, they cannot even claim seniority rights in the new company. That's the constitutional law. Subject to this, free will continues to be the hallmark of any contract. Employment, on the other hand, has a very wide meaning. It's different from appointment. Employment will include those terms which are, you can say, inquired rights, as the judges and the lawyers would say. So even promotions can be a part of employment. So therefore, when you say contract of employment, it would include not only contractual terms and conditions, but also those terms which can be understood and applied in practice or habitually by common consent without even being incorporated in the contract. Given this position, the terms and conditions of employment are set by enactments like Factory Acts, Mine and Plantation Acts, Shops and Establishment Act, the Bonus Act, Gratuity Act, etc. Various court decisions which have adjudicated disputes between management and labor on issues concerning wage rates, allowances, and a host of things which we will see a little bit later, by the process of collective bargaining between the unions and the management, and through custom, usage and practices. These actually set the contract of employment in any company, in any organization, in any industry. It's not one after the other, but it could be simultaneous also. For example, gratuity was being paid in India from 1950s by companies. But it became a compulsory payment when the Gratuity Act came into force, though the system of paying gratuity was prevalent much earlier also. Now, there are three types of employers, which Justice Sri Krishna mentioned. The government, and they have got their own service conditions, like Article 311, the civil service conduct rules, the public sector undertakings, and the private sector companies. We are only dealing with two of them, namely the public sector companies and the private sector companies. Why? Because under the Bangalore water supply company's case, they gave a very, very wide definition of industry. Therefore, almost all the public and private sector companies fall within the term industry. And we are looking into the contract of employment of management staff and the workman staff in these two sets of companies. Now, what are the enactments done? In the old Victorian days, whether a weaving shed had 10 looms or 100 looms, the owner could always handle three spheres of activity, like buying raw material, processing, and selling the goods. It needed no expertise. Today it is different. Apart from all these three areas, finance, accounting, personnel, HRD, everything is a specialized area. So much so that I was surprised to find that there is a consultant in Pune, based in Pune, who only specializes in productivity fixing, linking productivity wages. He does nothing else. He says your company can improve productivity by so and so extent within so many hours of work, and there is no additional labor cost. In fact, the unit labor cost keeps falling. So specialization has reached such a stage that the old method of running organizations cannot continue any further. But in the old days, one thing happened. Along with one man buying, selling, and processing goods, there was ample supply of labor, though the productivity of labor was very low. Now, this labor was cheap, that led to exploitation, and that made the governments to bring about laws, and the aim of labor legislation then was to check, control, and circumscribe uncontrolled managerial power. They also said, we will fix minimum terms regarding hours of work, rest intervals, overtime pay, holiday with pay, annual paid leave, safety measures, welfare facilities, employment of young women and young persons also, women and young persons. The aim was to introduce some kind of order in workplace, predict human behavior in workplace. How do we predict? That when you say 8 hours is your working hours, duty hours, you expected people to turn up on time. Thus, it provided for predicting behavior of employees, it provided for control over the working life of the employees, and also it assured certain minimum safety standards and protection of workers as well. That was the aim of labor legislation. It provided for general set of conditions of work. It may not be specific to each industry, but law provided initially the thrust for specific conditions of work. And then came the adjudication proceedings. Adjudication proceedings also dealt with all those things like wages, bearers allowance, leave rules, transfers, etc. But that was applicable to specific companies where the employers and employees raised disputes. And here I find that the two things, they are mechanization and computerization. The courts have delivered judgments how the managements can mechanize and computerize their workplace in two instances. One is in the case of Reserve Bank of India, where the union had opposed computerization for several years. The Reserve Bank, through the National Industrial Tribunal, got an award on computerization. The same was the case of the Greenwich Bank also, where the tribunal provided for computerization and the terms for computerization. Most of the other banks had this through collective bargaining processes, but where the Marxist Union disagreed, this was the only way out, and that too to achieve the result through collective bargaining process. Now, here I find that the Bombay industrial tribunals in the Bombay courts are much more mature than the courts in other parts of the country, because one eminent lawyer, Jinwala, told me once that it is because your dispute was in Bombay that you got computerization. If the dispute had come to Calcutta, you wouldn't have got anything. So Bombay courts are, they quite understand the commercial constraints, the commercial needs, and perhaps this is not there in other courts. The recent example is what happened last week in Kerala. They had an old port which had containerized traffic, but the new port which was inaugurated by the Prime Minister had much better facilities, so that international movement of goods and containerized traffic could be facilitated. The clear understanding was, once the new port starts, the old port will be closed. The employees of the old port went to the port and said, we will lose our jobs. So the port said, okay, we'll solve this problem. You will not lose your job, and the employer will not do his work also. How? He says, the domestic traffic in the ports will go to the old port. So if Bombay were to send some material to Cochin, it will go to the old port. And if some international traffic comes, that will go to the new port itself. Now the judge did not realize that a ship, because of the space it has, it carries both national and international cargo. So you go and first stand in the queue of the national port side for 20 days to get a berth. And after you discharge the cargo, go and stand in the international port, the same area, for another 20 days to get, berthing facilities. So we are living in heaven in Bombay in the sense that the judges do understand the commercial constraints, and the judgments have all through been quite good. The courts have always acted on two principles. One is what is known as the industry cum region principle, where a fair cross-section of the industry is taken as the guiding factor, and the courts try to give uniform conditions of service all over the industry, so that there is no unfair competition amongst workers and no cherry picking was allowed. The second thing was that the courts always took into account the financial capacity of the employers and looked into several years of trading result instead of 1 or 2 years. Therefore, the judgments given in the earlier days were very well balanced. But then there comes one catch. All these decisions in the old days were basically based on what is known as the principles of social justice. Justice Chagla was one of the first to expound the principles. And he said that the concept of social justice and economic justice is a living concept. Applied to industrial adjudication, it meant to adjust between the rival claims of employer and workmen in a fair and just manner. Following this, Justice Gajendra Gadkar, the Banking Award Commission report, gave a very wonderful, what shall I say, not a twist, but a push to the concept by saying that it has to be in tune with the needs of the times. So it is not one stagnant concept. It needs to change from time to time, and you need to take into account both the interest of the industry and the employers, and not only these two parties, but even the public interest and that should keep in tune with the time. This philosophy held good till about the end of 1960s. And then came the era of socialist principles and, activism. So one of the first casualties that time was that some of the judges felt where the law is silent, the judges should pronounce law. So if you look at section 11A, it only speaks of the right of the labor court and the industrial tribunal to reduce the punishment if they feel that the worker's right has not been done justice with. But one of the judges said that even arbitrators are included in the concept of labor court and tribunals. That was the starting point, and the philosophy then was that blood, toil, sweat and tears for workers and all production and profit for management, and that was an industrial irony. This is the concept with which they started. Now I must say one thing, that these judges gave to the working class much, much more than what the trade unions gave to the working class. That was a time when Sundarmani's case came up, where the judges said that if anybody's service is terminated in violation of section 25F, if he has completed 240 days of service, he will surely be reinstated. A host of cases in banking industry followed, other industries also it followed, and a number of people got reinstated because of this one simple judgment. I must take you to the Bank of Baroda's case also. In Goyal versus Bank of Baroda, the Maharashtra government refused to refer the matter for adjudication. The Supreme Court intervened and said that it is for judiciary to decide whether the dismissal is right or wrong, and the government has no power not to refer the dispute for adjudication. It was correct. But in the context in which it is set, the government became absolutely functionless in the matter of referring industrial disputes to adjudication. The judges dragged in thereafter Article 14 and 22 of the Constitution to very simple cases where the employee is absented for 8 days or 10 days under the standing orders without permission, and then they said that you cannot discharge these employees, or you cannot treat them as having abandoned the contract of employment. You need to show cause and give him an opportunity to explain why he has not come and reported. Then there were 3 retirement benefits cases. In the old days, Provident Fund and gratuity were considered to be the terminal benefits. Banks had, in addition to Provident Fund and gratuity, pensions are also State Bank of India, for example, and the foreign banks. When the Gratuity Act came into force in 1970, the courts took the view that once the Gratuity Act has come into force, gratuity is compulsorily payable. The foreign banks in their wisdom, as also the Bharat Petroleum in its wisdom, they started paring down pension by the annuity value of gratuity. And the result was the gratuity was paid in full, pension amounts stood reduced, and Provident Fund, both employers and employees' contribution was also paid. And the Supreme Court said, you cannot take away or pare down pension because you are giving gratuity. All the 3 benefits in full are payable. So in banking industry, for the first time in the foreign banks, and in the case of Bharat Petroleum, the 3 retirement benefits as a concept came into existence. And soon enough, I see over the next 5-10 years, it will come and engulf the industries all over. And the starting point was the decision given by the judiciary. In Menaka Gandhi's case, they introduced a 3rd principle of natural justice. They said no man shall be condemned unheard, and no man shall be the judge of his own cause. Justice Bhagwati added and said that you cannot adopt any method unknown to law while conducting domestic inquiries. There are several other judgments. I would like to draw your attention to only 3 of them, which actually frustrated the management of those days. The first judgment was in the case of one R.V. Patil in Ahmedabad. He was an employee of the sales tax department. He was caught for accepting bribes and he was dismissed from service after holding an inquiry. He went and joined the municipal corporation of Ahmedabad, did not disclose that he was dismissed from service from the sales tax department, and when it came to light, the municipal corporation charge sheeted him, held an inquiry and dismissed him. And the court said, you have got no business to bring what he did in his previous employment to this employment, and therefore he should continue his service. This was a very frustrating judgment in those days. The next one was, of course, the Parsi gentleman. I mean, nothing against them. It seems he went and abused one of our supervisors in, you know how Parsi people speak in one of those most vulgar and severe terms. He was dismissed. And the court said, no, they use this language even at home. And therefore